right, I'd like to call this meeting to order, the May 15th, 2013 Zoning Board of Appeals meeting. The first item is roll call. It looks like we have everyone here except for Mr. Bolia. If you could note that for the record, please. I'd like to start out the meeting by reading the Zoning Board of Appeals Chairman's Preamble that we read before every meeting, just so everyone understands the purpose of the Zoning Board of Appeals. The Zoning Board of Appeals is charged with the responsibility of granting variances, ordinance requirements, after determining whether there exists an undue hardship upon an applicant if a variance is not granted. In determining whether or not to grant a variance, the board shall apply the criteria specified in section 27-916 of the zoning ordinance to the facts of each case. The board further hears applications where it is alleged that an administrative official erred in a final order, requirement, or decision based on or made in the enforcement of the zoning ordinance. The Zoning Board of Appeals does not create zoning, nor can it change zoning. The board has no authority to grant variances for use, density, or height. Matters brought before the Zoning Board of Appeals are to be concerned only with variances from development standards placed on property by the zoning ordinance. Final decisions of the Zoning Board of Appeals may be appealed by petitioning the Superior Court of DeKalb County within 30 days after the decision is rendered. All right. Our next order of business is the approval of the April minutes. Has everyone had a chance to review those minutes?
Mr. Chairman, on item number 6, page 12, I was the lone dissenting vote, not Mr. Self, so doesn't need to change.
Okay.
Do I need to make a motion to unmove it?
Let's see if there was anyone else had any changes. Okay. It does not seem like we have any other changes. Would you like to make a motion, Mr. Barnes?
I move that we accept or approve the minutes as amended.
Okay. I'll second that. All right. Any discussion on the matter? All right. All those in favor of the approval of the minutes from the April meeting as amended, please signify by raising your hand and saying aye.
Aye.
Aye. Aye. All those opposed? Okay. The minutes are adopted. Our next item on the agenda is our organizational and procedural items, and we have some revised rules and procedures to discuss this evening. I'll defer to Howard to give us an update on the changes to the rules.
Thank you, Mr. Chairman. There are 3 proposed changes in your rules and procedures. The first change is noted on the packet page 23, which is actually the 3rd page of the rules and procedures themselves, and it relates to the order of business, section 12. We've changed the rules and procedures to better match how the agendas are actually laid out. If you go to the next page, which is packet page 24, Section 17A, public comments, is now no longer required as it related to one of the portions in the first change. So that was able to be removed. And then the last item is on the last page of the rules and procedures, which is your page 26 in the packet, related to Section 22. It increases the maximum number of agenda items from 5 to 10.
Okay. Anyone have any questions for staff on the revised rules and procedures? Okay, if not, I'll open the floor for a motion.
I'll make a motion to approve the revised rules as written before us.
I'll second.
All right, so we have a motion and a second to adopt the revised rules and procedures. All those in favor signify by raising your hand and saying aye.
Aye.
All opposed? Okay, the revised rules and procedures have been adopted. All right, moving on to unfinished business. First item on the agenda is case AA13-031, formerly DeKalb County case A-13-18379. Kathryn M. Zickert and Dennis J. Webb Jr. of Smith, Gambrell and Russell LLP, located at 1230 Peachtree Street Northeast, Atlanta, Georgia 30309. Are representing Teresa Tomlinson, 3770 Peachtree Road LLC, et al., the applicants for the following: an appeal of an administrative decision to deny approval of an overlay certificate of compliance and a pending application for a land disturbance permit. The addresses of the subject properties are 3770 and 3804 Peachtree Road Northeast, Atlanta, Georgia 30319. The tax parcels of the subject properties are 18,239,02001 and 18,239,02002. I'll ask Ms. Cannon if we can get a staff update and recommendation.
Thank you, Mr. Chairman. As we're all aware, this item was deferred from the December 20th meeting, and at this point in time, we have received a request from the attorneys, from the applicant's attorney, Ms. Kathy Zickert, requesting a deferral for 6 months, which would be to a date certain of November 20th. The staff supports the request for deferral for that period of time, and Ms. Zickert is here tonight if you have any questions in that regard.
Okay. Thank you very much. Ms. Zickert, if you could confirm that you have requested a 6-month deferral to the November 20th date? Okay. Thank you very much. All right. I'll open this up to the board for discussion.
I reviewed some of the materials, well, all the materials submitted, but I noted particularly that there's an attempt or a plan or an idea to add the 0.77 acre piece that's in the city of Atlanta to the overall development to make it a comprehensive development. And it's my observation in regard to that integrating the two properties into one comprehensive development would have improved the traffic flow through the project and allow for a better possibility to direct traffic to Club Drive, which would put it by the light and reduce the traffic that would be spilled out onto Bel Air. It would give the residents an option to come out at that light, and I think would help one of the concerns of the Bel Air residents. And so to integrate this property with the City of Atlanta piece, which would require rezoning, I believe, makes sense to me.
Okay. Any other comments?
Mr. Chairman, do we have the ability to grant a deferral for 6 months?
I'd like to defer to the city attorney for that, please.
Use a mic, Scott.
What we do is the court.
Use a mic, Scott, please.
The code actually does state that there are 60 days in which the board needs to make a decision. What that provision is there for, it's for the protection of the applicant. What it is, that's there to make sure that an application doesn't sit in front of the board for 6 months, 9 months, a year, just something longer, with the applicant languishing without an answer. It's to protect the applicant's legal due process. And if the applicant is the one that's requesting a deferral, the applicant's due process is protected. So yes, on motion by the applicant, the board is able to defer to a date certain, which we've done November 20th. So they would be able to defer beyond that 60 days because it is, again, it's protecting the applicant, and since the applicant is the one that's requesting it, the board does have that ability to do it. And the applicant, by request, is not able to do it unilaterally. So they can't simply, by their request, say, we'd like to defer for 6 months, and it just happens. The deferral still needs to be approved by the board. So we're respecting the entirety of the due process of the entire process that we're going through right now.
Okay, thank you for that clarification. If there's no other comments for the board, I'll open the floor.
Mr. Chairman, one further question for Mr. Robichaud. Is there a benefit to the deferral over a withdrawal of the application and then reapplying when they have everything in order that they need for the application.
If they withdraw, there actually is, I believe, a penalty that's involved. But what I can say is I'll list a lot of the options they can do. That may be happening. What happens, I was asked what happens if the board decides to deny the application, and then they've seen they might be able to reapply in their 6 months, and that actually would not be permitted. The code actually says that if the board denies something, there is a 24-month period in which they cannot successively apply for the same variance, and so that's would be the effect of a denial. For withdrawal, there would be a penalty, and we'll look up exactly what that penalty is, but there is an impact to the applicant itself. And versus a deferral, it keeps everything in place. It lets us know that this is an ongoing matter in front of the board, and that we know that we'll be looking at it at a specific date certain in the future. Still not talking? Sorry.
All right.
I have another question for Mr. Robichaud. So we have two choices tonight: accept the deferral or make a vote on the actual application. Is that right?
That is correct.
And the application has to be voted on as is. There's no opportunity to modify or adjust, so it's a up or down vote.
The board can always propose and make amendments to any kind of motion. So if it would like to be a motion to approve, there can be amendments to it. So it can be like putting conditions on it, that type of thing.
Okay.
So, but correct, it would be approve or deny, or you can defer that decision. And that's really the decision you're deferring, whether or not to approve or deny the decision.
Right. I guess the point I wanted to make was that if we were to make a decision one way or the other, the only redress of the party that the decision went against would be to go to Superior Court.
That's correct.
Okay. So deferral keeps it out of court for the time being and allows additional negotiation or work to take place, and the applicant has indicated an intent to try to reduce, I think, the density and try to present a more appropriate project, if you will. That's my understanding. Is that staff's understanding?
That is our understanding.
Okay. Thank you.
That is correct. For any decision of the board, especially a denial, the redress for someone's application that has been denied would be to appeal it to Superior Court, meaning, yes, a lawsuit in Superior Court. So that would be the redress that they would have, versus the deferral does, again, push it to a date certain. We've got November 20th, in which the approval or denial vote would happen at that point.
Okay. If we have no further discussion, I'll entertain a motion on this item.
Mr. Chairman, I'll move to defer until that set date of November 20th.
Do I hear a second?
I'll second that.
Okay, so the motion has been made to defer item AA 13-031 for 6 months to the November ZBA meeting, which is November 20th, 2013, as I understand it. All those in favor of the deferral, please signify by
Chairman?
raising your hand.
I'm going to ask, after the motion and the second, we would ask if there are any additional comments or questions by the board.
Okay. Any additional questions or comments by the board? All right. So the motion, as I understand it, is on item AA 13-031 to defer that for a period of 6 months to the November 20th, 2013 ZBA meeting. All those in favor of the deferral, please raise your hand and signify by saying aye.
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 All opposed? Aye. Okay. I believe the motion passes 5-2. Order, please. We still have agenda items to take care of. Item number 2.
Mr. Chairman, if you'd like to entertain just a short recess, we can have people leave and maybe able to get a better recording afterwards.
We'll take a 2-minute recess and start back up next week. Okay, we'll go ahead and reconvene the meeting now. We're on unfinished business, item number 2, which is item number 2 is ZBA case 13-042, Sean Cash of 4510 Wieuca Road, Atlanta, Georgia 30342, seeks the following: a variance to 27-788A to reduce an average front yard setback from 71.8 feet to 45 feet at a property located at 4142 Shawnee Lane. If we could please get an update from staff on the recommendation for that.
Thank you, Mr. Chairman. You'll recall this was heard at the last regular meeting we had. The application which staff supported was deferred for a month so that the applicant could speak with adjoining property owners about the impact of the project on adjoining properties. The applicant has not been able to make any additional information known to the staff, but he is here this evening with an update for you, and we can continue the proceedings from last month.
Okay. All right. Mr. Gash, if you could give us an update on where we stand since the last meeting?
We've, of course, previously we were at 45.
Hello?
Okay. Previously, we were asking for 45 feet reduction from the average front yard setback, which was, I think, 71.8 feet. Now we've actually, we could either stay with this plan, we've talked to the neighbors, or we've come up with another plan where we would move the house closer to their house actually, but it might make it, that their main concern was to, was that the house was going to stick out too much in front of, towards Shawnee Lane. They wanted more in line. They wanted it more in line with their house. Now, with the curvature of the road, you know, our argument was it will seem more set back from the road because it curves outwards. We have a new site plan, which will actually bring us from 45 feet to 48 feet. And it might bring it more. Here's where their 60-foot line is from their house. The porch goes out a little bit, and that's what would bring it to approximately 48 feet from the property line. Without the porch, I'm not sure if the porch is included in the zoning ordinance, if that counts, but the porch is approximately 8 feet from the house.
Okay.
So we've made a revision. Whichever one works is fine with us. We didn't want to encroach further into the rear yard or side yard. We didn't want to encroach in any other setbacks. But the main hardship is the buildable area is very, very thin on this lot. So we're trying to stay within that as much as we can and have a house that will be more to the newer houses, be more like the newer houses being built in the neighborhood in the area.
Okay. All right. Thank you very much for the update.
Could you just explain one more time, with and maybe without the porch, the new setback reduction request? Clarify.
It would be from 71.8 feet to 48 feet. We were 48. We initially were that's with the front porch. We're initially asking for 45. In R4 zoning, for the ordinance, it's a 35-foot setback when you don't have to use the average.
Does that mean that the bulk of the house, the main frontage of the house, would be 56 feet from the front? From the
Yes.
right of way? Thank you.
Thank you.
Mr. Cash, you said that you did work with the neighbors.
Actually, John Gallinaro, who's with APAC Properties, did work with the neighbors.
Okay. And they seem to be pleased.
We'll call on them in just a second, because I see they're in attendance as well. Okay. Thank you. Okay. And ma'am, I apologize, I don't remember your name, but I know that you were opposed to this application originally. Could you give us an update, or would anybody like to give us an update in opposition?
My name is Larry Beckwith. I live at 4132 Shawnee Lane. I wasn't here for the first meeting. I was out of town. I appreciate the deferral time to have an opportunity to meet with the builders. I can definitely express that we're not pleased with either plan. And I've enlisted my good friend Liz Byer, who is much more experienced in such matters than I am, to help me out in conveying what our issues are with the plans that they presented. So with that, I would like to turn the time over to Liz Byer.
Point of clarification, Chairman. There actually is not a time limit right now. Right now, it is not a public hearing or public comment. These are, they are answering questions from council. I just want to make that point of clarification.
Okay. All right.
So what would that, actually I was going to ask you how much you would like us to, we do have the site plans with things colored in so that you can fully understand, because I realize that there's so many papers going around with Exhibit A, B, and C, which will take a little bit longer to explain, but if you'd like me to be able, if it's a 5-minute time limit, then how do you want me to?
What it is, it's not a time limit.
Okay.
Right now, what we're doing is, because the public hearing, public comment portion has been closed, what it is, we've reopened it to take questions or comments from
Got it.
council. So if they've got any questions or if they would like to see it, that is council's prerogative. So that would be up to them. If they've asked for an update, we could see what they would like.
Okay, so basically the board is in session at this point. It's not the public comment. Okay. I appreciate this. They had asked me, I've known Teresa for 20 years, and it just so happened that I have a lot of experience with zoning board of appeals, having served on DeKalb counties for 7 years, next to Rebecca Chase, Williams, for the prior time, and so I understand completely all the stuff that we handed to you. Sorry, the overlaying all that. So, but I did want to go through, because I do understand it to that degree. They
Ms.
want.
Byers, let's see if the board has any specific questions.
Okay.
And we'll allow you to answer those. When we come in. Does anybody have any questions they'd like to specifically ask?
Do you have something that can help me visualize? 'Cause
Yes,
the plan that
exactly,
the gentleman
yes.
showed is,
Yes, and this is a tricky one to understand, and that's why I have several different exhibits there, because of the way in which averaging setback is measured. But when it's on a curve, and the houses aren't following that curve.
Chairman, I'm
such
actually
as-
going to interject again, because this is not public comment, but she does need to be answering more specific questions.
Okay.
I understand that she's handing out some things, and you can review it and you can ask a specific question about it, but there really can't be a narrative about any kind of narrative type thing.
Okay. All right. Does anyone have any specific questions about the handouts that we have received?
where is the Beckwith's home in relation? Is it to the right or? Right here? Thank you.
It would be to the bottom of almost every one of these if you're looking at it from.
Okay. And Mr. Cash, Is this the amended plan that you've submitted, or is this the original plan that we see here? That's the amended with the 48 feet to the edge of the front porch.
Exhibit A or B?
B, okay. Okay.
B is the new proposal?
B is the new proposal, A is the one from last month, and D is how the existing footprint of the house is in relation to the adjacent parcels. So those are the three that speak to the footprints.
Okay. I actually have another question for Mr. Cash. On your amended plan on B here, if this is the 60-foot line here, and you're stating that your porch is 8 feet, it looks like that's pretty much where the porch connects to the house. Is that a correct statement? So if it's an 8-foot porch, I'm just trying to determine if we're at 48 feet or are we at 52 feet? So is the 52 the variance that you're requesting, or is it the 48? Okay, I just want to make sure we understand it completely. Okay.
What's the 48 foot Where's that coming from?
I don't see that printed on here, but I believe what he was saying was the old plan that they had submitted called for a reduction to 45 feet, and they moved that back another 3 feet to 48 and shifted the house to the left slightly. Is what it appears to me.
Exhibit A that we're looking at is the revised plan.
No, Exhibit B is the revised plan.
Okay.
Yeah.
Would I be able to address this question?
Okay. So with the revised plan that shifts the house to the left, you're talking about a 52-foot setback. Okay. Thank you very much for the clarification.
Okay, so it's the side.
You had a comment on that?
Well, yes, when they came back with the alternate plan, which was just, oddly enough, just last Friday, so we didn't have a great deal of time to look at it, we were greatly disappointed that the very thing that they did was create a greater impact on our property by moving the same plan to the 10-foot easement on our dividing property lines. So I don't feel that was a good faith effort to try to resolve an issue that we're working through. Plus, that particular plan was dated October 2nd, 2011. So I don't understand how it is that so many days have elapsed and we
Chairman, I'm
are at a
actually
point
going to
where...
interrupt again. I mean, this sounds again like a narrative.
Okay.
I know that we've got a lot of extra things. I believe the initial purpose of actually bringing up citizens in opposition was to just see if a deal or something had been brokered or worked out between them. And I don't want to speak for them. You may want to ask them themselves, but it sounds like nothing has been worked out, and that they still oppose the plan just in general.
Okay. All right.
Mr. Chairman, I have a question of the staff.
Okay.
Mr. Coons, do you have a recommendation on either, we'll call it Exhibit A or Exhibit B? Originally, the staff had recommended approval of the variance on Exhibit A. Do you have an opinion on one or the other, or both would be something you would recommend?
My concern with with Exhibit B as in boy is the rear yard encroachment on the northwest corner of the home. It looks like that's a new layout that's put the garage on the side of the house there, and it seems to be encroaching into the rear yard strictly from a planning and land use standpoint. the original application A seemed to be more justified for the same reasons that we had last month. The curvature of the road coupled with the encroachment of the rear boundary property line, which seems to push the building envelope, well, I shouldn't say push, but pinch the building envelope to be very wide and very narrow. As you look at the Exhibit B, which was presented this evening, all those setbacks are the same. The rear yard setback has not changed. However, they're pushing the home back towards that rear yard building envelope line, which is really what I believe is driving the request in the first place. So that's a concern. We still support the idea that the front yard setback to 45 feet is completely reasonable in light of the fact that the district standard, irrespective of averaging setbacks, but the district standard is 35 feet.
All right. Thank you, Mr. Prince.
So the standard, this is directed to staff, the standard setback is 35 feet.
In R100, yes, 35 feet from the property line.
What do you mean by district standard?
The building setback line for the front yard for all one-family detached structures in R100 district is 35 feet from the property line. That is the standard of the district.
Okay.
There is a requirement in the supplemental regulations of our zoning ordinance that reads, when a portion of a block is developed with 60% or more developed lots,
Right.
then any structures within 75 feet of a side lot line on a development lot need to be utilized and average those setbacks to create your own.
Right.
And
Okay.
on this street, in this instance, that number came out to 71.8 feet.
Mhm.
That's a large front yard
Mhm.
for Brookhaven. The district standard, it's been accepted, is 35 feet for lots that are similarly zoned to this one. So the request was to be able to build that home up to 45 feet, which is not a unique privilege that's been granted to this applicant as it's granted to every other R100 property in the city.
Mhm.
Okay. And we don't have any measurements on the two houses directly to the east of the Beckwith property, is that correct?
You mean across Shawnee on the other side of the street?
No, I'm talking the two adjacent properties on the other side.
Exhibit B is detailing front yard setbacks for the lot to the north, which is 4152, and the lot to the south, which is 4138. I'm sorry, 4132.
Let me get the parcel numbers correct. I don't have the street numbers here, but. Mr. Beckwith, this is your home right here, is that a correct statement in this area? Okay, that's all right. Okay, and these two houses are clearly in front of that. Okay. And they appear to be about 40 to 45 feet. This is the subject property here. This is the Beckwith's home. These are two houses directly east of the Beckwiths that it looks like their front is somewhere in the 40 to 45 foot range as well.
So is it fair to say that the average that we're required to consider staff is pushed to a greater level by the property on the other side, the non-objecting property owner is set further back, and that's what makes this average 71 feet. Am I seeing that right? You average the objecting party's frontage to the party on the other side of the applicant's property.
60.7 plus 83 divided by 2
Right.
is 71.8.
So this property on the other side.
Can you use the wireless mic when you do it?
Yes, it is. This is discussion amongst the board.
Can you use
Mr.
the microphone,
Beardsley,
Jen? Yeah.
thank you.
I think that the issue with the rear setback issue on the garage is a problem, but this house here is 83 feet back from the street, which pushes the average, and that creates that 71 foot. But the applicant, in order to get it further back, has had to slide it over because this is where the depth of the property is. And if you look at the bulk of these two houses, they're, except for the porch, they're substantially the same distance from the street, the way this has been redrawn. And you could even draw a straight line this way, that these three houses, if this house is put where Plan B took, these houses almost form a straight line this way. So, but for the curvature of the street and everything, they present a similar frontage. I'm inclined to try to help the applicant, except for the technical problem of the rear encroachment, which I don't know how we address because we can't create a new variance in this application. I also am inclined to think that if we can condition it so these trees are required to stay, it also buffers the impact of that house, appearing closer to the street. So my question to staff would be, if we approve the front setback, that really doesn't solve the problem.
Mr. Cash, can we ask you what your intention would be with this new plan that you've proposed with the garage sticking over that back corner? What is your intention there?
I think we're looking at two separate plans. I think there might have been a little bit of a mix-up. Because we're not proposing to encroach into the rear yard setback at all.
Okay, so this is not your new amended plan that we're looking at?
Mr. Chairman, if I may interject, the staff has not seen a revised plan from Mr. Cash.
Okay.
So if I can ask then to the staff, if we have not seen the revised plan,
So that's
Are
a
we-
totally different floor plan.
are we voting on that plan tonight, or are we voting on the plan as originally submitted? What is the,
What the board can do, the board can decide what to vote on. The board can vote on the plan as submitted, that's currently in your packets, or the board can vote on a revised plan. Something that is up to the board what they would like to do. What I would say is since staff has not had a chance to see or review the new site plan, that we would not be able to really fully answer all the questions, especially some of the detailed questions you're asking about full setbacks, possible backyard and things like that. We just haven't had a chance to review it yet.
Okay, but we would have the opportunity to amend the application and grant a variance from 71.8 feet to, say, 52 feet.
Yes, you would.
And then they would have a variance for 52 feet, and it's up to them to produce a plan that conforms to that.
That would be
And
correct.
submit that with their package. Is that correct, sir? Okay, thank
Yes,
you very
Mr.
much.
Chairman. And just as a point of clarification, it was actually advertised for up to for 45, so you can go all the way up to 45 in granting the application with that provision in it.
Okay, thank you for clarification.
Mr. Cash, why does this porch need to stick out so far? Is that just a design feature?
The front porch sticking out 8 feet.
Yeah, it's a design.
Is that heated and air-conditioned space, or is that just a portico?
Portico.
Portico. So,
Just covered.
so the front door to the house is to the back of that portico?
Correct.
Yes.
And it's kind of see-through design? I mean,
Correct.
a person could look through it.
There's a rendering on the back page. I don't want to get into redesigning the front of your building, but I've got a question for you, because I'm inclined to want to help him But of the two plans that are here, I understand your point, but it seems to me you're less impacted by Exhibit A because it's further away from the property line. I guess if you had a choice between the setback as shown on Exhibit A or Exhibit B.
And the reason for that is when we took the deferral to take the time to meet with the neighbors, their main concern was the average setback and that the house was going to dwarf and be in front of their house. So we sat down and said, okay, we can't redesign at this point. We're far along. We're 7 months into interest payments. Let's see what we can do to push it back and pull it more in line. That was their main concern. In doing so, we had to eliminate a garage. We were able to push it, but the only way to do that was to
Push it towards them.
push it towards them. So,
That's what I was asking.
and we did
them.
that because their concern was how far it was towards the street, not where it was in relation to the side yard setback.
Right.
And I think the question is to the homeowner, if you had to choose between the lesser two evils, what are you going to choose?
Well, our choice would be that the precedents that are set and the lot lines that are set already as part of the conditions would be conformed to. That would be our preference. Us having to choose between one bad plan versus a worse bad plan, I don't think that's how we ought to approach trying to solve this issue. We're not opposed to development taking place in our neighborhood. What we are opposed to is having the established construction and the sizes that are there compromised for only a business reason, not for enhancement of property or life or impact of anything else. So I'm not able to choose between two bad plans. What I'm looking for is conformity to the existing specifications and requirements that are there that govern, that have been established by legislative process. That's what we're looking for.
But you understand, sir, that we're here because variances are sometimes needed because of lot layouts, hardships, and, so you've got a big cut in the back here that limits it. You've got an artificial condition, or arguably artificial condition, created because this older house is set further back. Wouldn't it be fair, sir, if this house was the same distance from the street as your house?
We're interested in the minimum criteria being met. We're not looking for special privileges or special conditions. We're just interested in the minimum criteria being met. And the idea that somebody is 3 months.
Very pointed question about purpose and ability of the zoning board of appeals, not in general what you would like to see happen.
Okay. Thank you very much.
Mr. Chairman, I think we've had a lot of discussion on this. When the time's appropriate, I'd like to make a motion.
Does anyone else have any questions or any discussion before we entertain a motion? All right,
Mr. Chairman, I'm still not quite clear on the discussion of the 8-foot front porch. Is the variance requested then, if you're looking solely at Exhibit A, is the variance requested 45 feet or is it 8 feet? The porch is covered, so the porch counts as a part of the structure.
Okay. From what I understand, and you can just confirm this with a yes or no, based on the original submitted plan, you have a request to reduce it from 71.8 feet to 45.2 feet. You have in turn created a new plan which reduces the setback from 71.8 to 52 feet. That would include the porch as well, but that shifts the house all the way over to the left side of the property, putting it closer to the Beckwith's home. The Exhibit B that we have in front of us is not the new proposal that was presented tonight. It's a version of that, but they have removed the third side garage that is encroaching on that rear setback. So it looks like if we're going to call the two A and B, with A being the original, B would require a variance to 52 feet. Is that a correct statement? Okay. All right. But in turn, that does in turn push the house all the way over to the left-hand side of the lot, closer to the Beckwith's property. Does that help your question?
It does.
Okay. All right. All right. Mr. Billy, I believe you said you would like to make a motion.
Yes, and I'll be glad to comment on it, but I'd like to make a motion to approve the original request as approved by staff.
Okay.
And I'll be glad to comment on that.
We'll wait for discussion. Do we have a second on that?
I'll second that.
All right. So the motion has been to approve the variance of ZBA 13-042, reducing the front yard setback from 71.8 feet to 45 feet. I'll now open up the board for discussion on the motion at hand. Mr. Boley, you said you wanted to explain?
Yeah, my commentary on it is this is a plan that's been vetted by staff. They've approved it. They've had a chance to review it carefully. It's within, it's more than the 35 feet required by the overall zoning. If you look at it strictly from the sight line, it certainly is in line with the street line. I think the builder's done an effort to work out a plan. I don't think that the folks in opposition are going to accept anything other than what's there right now. So my inclination is to approve the plan as requested.
All right. Is there any other discussion?
Mr. Chairman, I just question whether the opponents might like to alter their position, because it seems to me to have that additional 7 feet of setback may make a difference. And if you see that the board is inclined, or a few members of the board are inclined to approve the original plan, does that alter your position at all?
I don't believe that we can address any questions.
What I'm going to say is that during this portion, the question should not be directed to citizens, to applicants or anything. You can ask staff pointed questions and we can answer that, but this really is about discussion amongst the board yourselves.
I've got a question. How far is the existing structure from the street? I don't think that's on.
That's Exhibit D, I think.
Okay. Yeah.
Okay, any other discussion about the motion?
I have a question for staff. All these trees shown on the plan, we have one plan with X's on the trees. Are those the only trees they would be able to take out, and would they be required to leave the grove of trees in the front?
I didn't review this for compliance with the tree ordinance, but from what I know about our tree ordinance, this would not be the only trees they are allowed to remove. They would be entitled to remove other ones. From looking at this plan and knowing what I know about the code, they are not required to retain the grove of trees up at the front of the property.
Doesn't the TS line mean tree save?
It does.
So we wouldn't have to condition our approval of anything on preserving the trees in the TS zone?
I don't believe that's accurate, no, because I think they can change the location of the tree safe fencing and still be compliant when they're done.
I would accept a friendly amendment to include them requiring them to save those trees.
Is that within our power, Mr. Obershaw?
That is within your power. It needs to be made actually by someone that did not make or second the original motion that we are now voting on.
I think it's a reasonable amendment. I'd like to move to amend the motion to add that provision.
Okay, so as I understand it, there is an amendment to the motion to add a condition to the variance that the trees currently located within the tree save fence in the front yard, there is an attempt to save those. Is that the motion as I understand it?
Right.
The amendment as I understand it?
Right.
Okay.
We would need a second on that.
Is there a second on that?
I'll second.
Okay. So the amendment has been seconded. All right, any discussion on the amendment to the motion?
I just got a question. What's the tree safe line for if not to save the trees? Why do we have to make an amendment?
The tree save line in this instance is just indicative of the way the construction will occur as a function of this site plan. When Board Member Beardsley had asked if those trees would be required to be saved, I think how I would answer him is that the tree save fencing could be moved. It could be shifted this way or that way to incorporate additional trees or to remove some of the ones that are actually listed to be saved now. And ultimately, at the end of the project, the site would still be compliant. The requirement is that you have a certain amount of density of trees on the lot post-construction. It's up to the applicant to decide which trees, so long as the minimum density is met, any of the trees that are on the site can be saved or can be removed, with some specific caveats for specimen trees notwithstanding. So his original question to me was, are the trees that we'll call the west side of the lot, on the west side of the tree safe fencing, are they required to be preserved? And the answer to that is technically no. They're not required to be preserved as a function of this site plan. They could amend this site plan to keep other trees that they have proposed for removal and instead remove those trees.
I have a question for staff. So if the standard setback for R100 is 35 feet, and the averaging for this lot should be 71.8 feet, which one trumps?
In this instance, the 71.8 feet is applicable because there is development of greater than 60% on this block.
I would like to be clear that my motion referred to the tree save area on the east side of the lot, on the Shawnee Lane frontage.
Councilmember Self, is that the amendment that you were also seconding? Is that what you
It
were
is.
understanding?
It is.
So for the over 60% of the lot have been developed, and they are closer to the 71.8 feet than the 45 or 35 feet, correct?
Can you state that again, please?
Most of the homes in the area are at the 71.8 setback.
The 71.8 is specific to this lot and only this lot, simply because the home to the north is, I believe, 83 or something to that effect, and the home to the south is 60.
So for the other homes, what are they set back at?
Well, the home to the south, we'll look at that one first, and that's stated that currently it's built 60 feet back from the right-of-way line. It would be the average of the home to the north and the home to its south. I don't know what the setback is to the home to its south, but it could be different. If the home south of that lot is, say, 40 feet, which is otherwise compliant with the ordinance, that would be the difference between 40 and, in this instance, I think we're talking about 52. So that would be 46 feet would be the requirement for a redevelopment lot. So the number changes as you go down the street, dependent upon the distance of those homes adjacent within 75 feet.
Okay, thank you.
But it would also be safe to say that the existing structure, if it were built today, would have to require a variance because it would be illegal under the zoning at 60 feet.
The existing structure today is 60 feet?
Yes.
Yeah, that's correct.
All right. Assuming there's no more discussion on the amendment, would we need to vote on the amendment to the motion prior to voting on the motion?
That's correct. You vote on the amendment first.
Okay. All right, is there any other discussion about the amendment to the motion? I will restate the amendment to the motion best as I can. There was an amendment to the motion to add a condition to a variance if granted that the trees located within the tree-safe fencing immediately bordering Shawnee Lane, that there is a condition placed that those need to be saved. Is that the correct way that you intended, Mr. Self, you said?
Yes.
Okay. All right. Seeing as though there's no other discussion on that, I'll open the vote on the amendment to the motion. All those in favor of the amendment to the motion, please signify by raising your hand and saying aye. Aye. All those opposed? Okay, the amendment to the motion passes. All right, so now we are back to the motion to grant the variance for ZBA 13-042. Is there any further discussion on the motion as amended?
Mr. Chairman, in the documentation that we have, do we have anything that shows other setbacks on the street? Am I just missing that?
There's no documentation. I have an aerial photograph that I pulled up after visiting the site and looking at the houses on the other side of the Beckwith property, and their front setback is significantly closer to the street. But I do not have a surveyor's.
And that's primarily because of the garages on here, correct?
Correct. But the front of your building, whether it's garage or whatever, that is your front setback. Anything under roof falls into the setback.
Okay.
All right, any other discussion about the motion at hand? All right, so we have a motion for approval of ZBA 13042, Sean Cash of 4510 Wieuca Road, Atlanta, Georgia 30342. Seeks the following variance, a variance to 27-788A to reduce an average front yard setback from 71.8 feet to 45 feet at a property located at 4142 Shawnee Lane. And there's a condition placed upon that the applicant will save the trees located within the tree-safe fence area immediately adjacent to Shawnee Lane as shown on their submitted plan. All those in favor of the motion, please signify by raising your hand and saying aye. Aye. All those opposed? The motion passes unanimously. All right, next item on the agenda is new business. We do not have any new business at hand. So I will now adjourn this meeting of the Zoning Board of Appeals for May 15th, 2013. Thank you.